then also there's some bond issues. So for arraignment purposes, Mr. Vogler, have you had a chance to review the charging document with your client?
I have.
And do you or your client wish to have that formally read into the record?
No, the reading is waived, Your Honor.
And how she wish to plead?
Just stand mute.
You will enter plea of not guilty on her behalf to a computer crime charge, tampering with evidence, 4th-degree child abuse, and looks like 3 counts of contributing to the delinquency. So forensic center referral requested?
No.
Estimated length of trial?
You have 2 or 3 days, I would think. 3.
Okay. Appropriate for docket call May 11 at 9:20.
Yeah, I think we could do that.
Okay.
Would that be at 9?
9:20.
9:20?
And then if you have need of time adjustments by stipulation, I'm pretty amenable to that.
All right.
We also have a couple bond issues. One looks like there was a bond violation that it was initiated in the district court and was included in the bind over set for then a hearing, or just continuing to track that. I don't know. That was for an alleged violation of the no contact by making a gesture to somebody that she was not allowed to have contact with. Then we've got a show cause that the prosecutor initiated after the bind over, as well as some additional information for some positive tests. I have been provided this morning, presumably through the defense, for with prescription information that seems to address those tests. Mr. McLean, have you been provided with that as well?
Yes, Your Honor.
Do you agree to then the dismissal of that contempt citation?
Yes, Your Honor. It looks like the positives are also covered by the prescriptions that Ms. Nastasia has, so we would be amenable to dismissal.
So the contempt for the positive tests is dismissed. How are you wishing to proceed, Mr. McLennan, on the pending violation for the no contact?
Your Honor, it was just this morning, actually, that we just recently received the additional video we needed, and I reviewed it this morning to speak now with the complaining witness in that matter about this.
Okay, so you want us to just continue that matter then?
Yes, Your Honor.
Okay. And will that, do you want me to continue that just as sort of a status conference on it, or do you want me to continue it for an evidentiary for some brief testimony at our next docket call about that? I mean, I can set it on there as allowing testimony. And then if you guys don't want to proceed on that, you certainly.
I think that works best, Your Honor.
Okay, so we'll set it for the docket call and a bond violation hearing for May 11th at 9:20 a.m. And Mr. Clennon, anything else on behalf of the people?
No, Your Honor.
Mr. Vogler on behalf of the defense?
No.
Okay, you're all set for this discussion.
Thank you.
To bring us to People v. Brandy Fisher.
Good morning.
Looks like we've got 3 files. 1-93178FH for a docket call and some bond motions. I'm sorry, bond motion for the defense. 25-93385, a docket call, and 26-93393FH for an arraignment on an abscond. So, Mr. Vogler, I guess let's take the arraignment first to get that done. Have you had a chance to view the charging document with your client for the absconding?
I have, Your Honor.
Any, do you or your client wish to have those allegations read?
It's not necessary, Your Honor. She's going to be pleading on
Okay.
that.
And the Forensic Center referrals not requested?
No.
Okay, so Ms. Fisher, would you raise your right hand for me as best you can? Swear to tell the truth, the whole truth, and nothing but the truth, so help you
I
God?
do, Your Honor.
Okay, you put your hand down. Now, Ms. Fisher, a guilty plea hearing is an important event because it includes the waiver of constitutional rights that you have. So I want you to listen carefully. If you have a question, go ahead and ask me. I'm happy to answer it. If you need a minute with Mr. Vogler, just let us know.
Yes, sir.
I have to advise you the maximum penalty that you could face for the charges that you're offering to plead to. In 93178, it's you're pleading as charged in that file. Count 1 is third-degree child abuse. It's felony, punishable by up to 2 years in prison or probation for up to 5 years. Count 2 is third-degree child abuse committed in the presence of another child, and that's a felony punishable by up to 2 years in prison. And in file, it says 260018FY, that's the 26-93393FH number in the circuit court. And that's a charge for absconding or forfeiting a bond. That's a felony punishable by a maximum of 4 years in prison and or $5,000 fine. And that would be discretionary consecutive sentencing. So the maximum penalty that you could face would be the 2 years on the child abuse, both counts would be concurrent, plus 4 years for the absconding. So the maximum penalty that you could face under law would be 6 years in prison. Do you understand that?
I do, Your Honor.
Are you on probation or parole anywhere?
I've never been in trouble.
Okay. And did you read and understand the rights listed on the advice of rights form that you signed?
I did, Your Honor.
Okay. Do you understand that lists the rights that you give up when you don't go to trial and plead guilty?
I do, Your Honor.
Do you have any questions for me or Mr. Vogler about any of those rights?
I don't at this time, sir.
Do you wish to give up those rights in honor of this plea?
I do, Your Honor.
If I accept your plea, you give up any claim that it was caused by threats or by promises beyond the plea. Do you understand that?
I do, Your Honor.
Also, when you plead guilty, you lose the right to appeal. And if you want to appeal, you have to seek permission by filing an application. And the types of issues that you could raise on an appeal after you plead guilty are very limited, much more limited than if you were convicted after a trial. Do you understand that?
I do.
All right, the plea agreement provides that in exchange for your plea to those charges, the 93385 FH file will be dismissed in its entirety. And the prosecutor's agreeing not to seek additional charges in the 93178 case, that they were going to seek a remand or additional charges for felonious assault and or first or second degree child abuse. And also there was a time deadline that this had to be entered today for it to, that it would expire if you didn't enter this plea today. Do you understand the terms of that plea agreement?
I do, Your Honor.
Mr. Vogler, is it a full, fair, and accurate statement of those terms?
Yes.
Mr. McLennan or Mr. Virgo, is that correct?
Yes, Your Honor.
All right, Ms. Fisher, other than the plea agreement, has anybody promised you anything to get you to plead guilty to?
No, Your Honor.
Has anybody threatened you to make you do so?
No, Your Honor.
Is it your own free choice to do?
Yes, Your Honor.
Knowing all this, how do you wish to plead in 93178 to the charge of child abuse in the third degree?
Guilty, Your Honor.
And how do you wish to plead to the charge in count 2, child abuse in the third degree committed in the presence of another child?
Guilty, Your Honor.
Mr. Vogler, could you assist with the factual basis? I don't really know much about that.
Yes, Ms. Fisher, on or about in the summer of 2019 or summer of 2020, were you residing in the city of Rutgers City?
I was, sir.
And at that time, you had a daughter living with you, is that correct?
I did, Your Honor.
And
I did, sir.
how old was she?
I want to say about 8.
8. And you were also taking care of a young boy, is that correct?
Yes, sir.
And how old was that child?
Around 3, 4.
So on or about, I guess, the summer of 2019, you have that boy, were you taking care of him for his mother?
Yes, sir.
And at that time, did you lose your temper as a result of something that boy did?
I did.
And in the process of losing your temper, did you swear at him loudly, repeatedly?
I did.
Did you grab him roughly and violently by the shirt?
I did.
Did you yell at him repeatedly, loudly to shut up?
Yes, sir.
And at one point, did you strike him hard 4 times with a stick on the small of his back?
Yes, sir.
And as a result of that, did you cause him physical harm?
I did.
And that is, you harmed him in some way, leaving red marks or something?
Yes.
Your Honor, I think that's our factual basis.
And that was committed in the presence of the other child as well?
Yes, I'm sorry.
Okay.
You want to say that?
Yes.
Okay. All right, you satisfied with that factual basis, Mr. Virgo?
Yes, Your
Child abuse charges, okay. And Ms. Fisher, in 393 FH, how do you wish to plead the charge of absconding or forfeiting a bond?
Guilty, Your Honor.
So in the child abuse case, you were on a bond given by this court, is that
I
correct?
was.
And as part of that bond, you had to appear for court as ordered, is that right?
If that is correct.
And did you fail to appear for a court hearing?
I did, sir.
Okay, and then you did no longer lived within the confines of Prescott County, is that right? You
That is
moved away.
correct.
Okay. And then you were arrested on that violation of your bond. In what year?
I turned myself in, sir.
Okay, turned yourself in downstate.
No, here. I
Okay,
walked in, I
okay.
called George and let him know I was coming to turn myself
Okay,
in.
and you came up and turned yourself in.
Yes.
That was late last year,
November 5th.
November.
Yes, sir.
November last year. Okay.
Your Honor, we were going to take the forfeiting of bond fork on this particular charge.
Okay.
I have reviewed the court file. It looked to me like the court, her bond was.
Okay, so Ms.
Forfeited.
Fisher, as a result of you not appearing at a court hearing, did the court enter an order forfeiting your bond then?
Yes.
Okay, all
Yes.
right, and you haven't contested that bond forfeiture?
Not understanding.
You haven't challenged that forfeiture of your bond?
No, we did.
No,
Okay, you didn't come in and file any motion to say like,
no, sir.
you shouldn't have
sorry.
forfeited my bond, I didn't have
No,
notice of court?
I came in and the
Okay.
bond was revoked and then you set me a new bond,
Okay,
if that makes sense.
yeah, all right, Mr. Virgo, you satisfied with that factual basis?
Yes,
Mr. Vogler, are you aware of any other promises, threats, or inducements for this plea?
No, I'm not.
Mr. Virgo?
no, Your Honor, there are no.
And Mr. Vogler, in your judgment, has the court complied with the requirements of MCR 6.302?
Yes.
Mr. Virgo?
The court has.
All right, Ms. Fisher, I find that your plea is knowingly, understandingly, and voluntarily made, and that there is a sufficient basis in fact and law to believe that you're guilty of those offenses. So I'll accept your plea and we'll schedule sentencing for May 11 at 10 a.m. You'll have to cooperate with the with an interview with the probation department so they can write a report recommending what the sentence ought to be.
Yes, Your Honor.
All right, and Mr. Vogler, did you wish to be heard on the bond motion?
Yes, Your Honor, we're asking the court to allow Ms. Fisher to have contact with her minor children. She's got a son and a daughter. Both of those children are under the jurisdiction of the Macomb County Circuit Court in the Family Division, pursuant to a petition on the Child Protective Proceeding. The respondent is the father, Terrence Goldman. My client is a non-respondent mother. Based on what has transpired there to date, the children were actually, but for this case, would be with her right now. But because of this case, she signed a delegation of parental duties to her sister, so the children are actually in her sister's care. She has undergone from the very beginning, way back in 2021 when she was first arrested and started out with another lawyer. She was in counseling and she went through a 6-week anger management program, which she successfully completed. And I provided a copy of that to the prosecutor last week. She also has been engaged in family counseling through the family court, and that's been the same counselor. There's a counselor that counsels with the children, and that same counselor counsels with her. Provided a letter to the prosecutor from that counseling, and everything there was positive. It showed that my client was working very diligently at changing her life and trying to become so that something like this doesn't happen again. This is a case that happened 6 years ago, 7 years ago. She's done a lot to try to change her life and to make herself a better person. In fact, I think, goes without saying, I think she shouldn't have been, but she was ignorant of the fact that she shouldn't have had contact with her kids. But I think while she's been in jail, there's been some contact that has occurred, not face to face, but phone and video, until corrections looked at the paperwork and said, well, you can't do that. We think in the long term here, even the most recent order out of the Macomb Family Court, which was February 17th, indicated that she would have supervised visitation with her kids. That, however, is subject to the order of any other court that's out there, and the only other court that's out there is this court. And I believe that this court should lift that and allow the family court in Macomb County to make determinations and set the parameters of what contact she should have with her kids. I think they're more equipped and better equipped to do that.
Thank you, Mr. Booth. Mr. Wirgo, people's position.
Your Honor, the people aggressively oppose defendant's motion. Defense has stated that but for this case, she'd have the kids. I would disagree and say, but for the way she framed this case for the folks down in Macomb. she would have her kids. Because, Your Honor, last week, it baffled me after seeing the video of this abuse, which one of her children was the minor that was present for that, that anybody would be considering this. I have since sent the video to the worker that is handling that. They have reversed their position. They are in favor of her not having any contact with the children, Your Honor, and
the boy wails. He begs because he knows it's happening, and she does it anyway.
Boy wails. He begs because he knows it's happening, and she does it anyway. 6 weeks of anger management doesn't fix that, Your Honor. Those kids would be in danger if she were allowed to see them. She's already violated the order. Your Honor, please do not change those bond conditions, and do not let her have
I mean, that
contact.
did happen she just pled to it, so she's not contesting that happened. But, you know, the fact that happened doesn't mean she never gets to see her kids again for the rest of her life, right?
No, it doesn't, Your Honor, but we need
So how
more.
many years got to go by before we?
Not years, Your Honor. Counseling, therapy, real work, not a 6-week anger management class, Your Honor.
Your Honor, if I could just respond.
Sure.
In all due respect to the assistant prosecutor, the court, first of all, DHS has had this video in their possession since 2021. The fact that it may or may not have gone down to Macomb County DHS, that's problematic on their end. However, if this DHS worker, who is new to the case, as I understand it, has that position, she is in her rights to go to the family court in Macomb County and change it. And that court is way more going to be way more informed and have way more knowledge and be in a better position to make a ruling there than I think this is.
All right, well, here's what I'm going to do. I did reset a bond that Ms. Fisher was unable to post. Now she has pled, and one of those was for an absconding as well. Post plea bond is discretionary with the court. I think there are a lot of moving pieces that I want to hear about to determine, you know, what the proper sentence is going to be. So what I'm going to do is in these files, I'm going to enter an order that her bond will be revoked, and she'll be in custody of the Presque Isle County Sheriff until further order of the court. But I am in file 93178 in order that the no contact provisions be rescinded or lifted. So she's still in the jail, but then she can have, you know, whatever video or telephonic contact is arranged consistent with an order of the Macomb County Court. All right, and then we'll see you on May 11th for sentence.
This case leaves a heavy question hanging in the air. How do you balance accountability with the possibility of change? The court accepted her plea, but the emotional weight of what happened, especially to those children, doesn't just disappear. Legally, this shows how plea deals can limit harsher charges while still holding someone responsible, but they don't erase the past. And when it comes to child safety, courts will always err on the side of protection first. Now the real question is: should rehabilitation ever outweigh the risk when children are involved, or is some damage simply too serious to overlook?